Welcome, everybody. I see a number of people have joined already. We'll just wait until the official start time to get started on the content. Thank you so much for joining this evening. Okay, we're going to get started in about 2 minutes. Hi, Keith. It's great to see you come. Hi, Francis. Thanks for joining, everybody. Just wait 1 or 2 more minutes till the official start time to get started in case anybody else is joining today. Okay, we're going to get started in about 1 minute now. All right, let's get started. So I'm Samar. I'm an immigration and global mobility partner at Spencer West Solicitors. And this is a webinar on the UK's future immigration system. Thank you, everybody, for joining. These are very strange times we're living through. I hope everybody's healthy and well. And yeah, I just want to say thank you very much for joining this evening. So we are going to talk about the immigration system. A few housekeeping points. I would recommend a side-by-side viewing mode, so you'd be able to see me and the slides. If you go to the top right next to the green bar, you should have view options listed there, and then you should be able to select side-by-side viewing mode. These are just some suggestions because some of us are newer to the Zoomiverse than others. Anybody who's been to a presentation of mine before knows that I really like to engage audiences as much as possible. I like as much interaction as possible. And we're going to try to do that this evening in the webinar format as well. So I really encourage you to use the Q&A function. If you hover over usually the lower part of your screen, a control bar should appear, and you'll be able to type a question in there. I will try to get to as many questions as possible, but if I don't get to your question today, I'll try to follow up by email. You can also like other people's questions, you know, clicking on a thumbs up as you would on some social media platforms, and then I'll know that a lot of people are interested in that question and I'll try my best to answer those questions that people are most interested in. We'll also be doing a couple of polls. I've prepared some poll questions for you to answer, and I'll be asking you to raise your hand at some points, as you've just done, Hardik. Thank you. Okay, so let's get started. I'll just talk a bit about what I mean by the future immigration system in the UK. So it's a system that the Home Office has said will be in place by the 1st of January 2021, but it's not like everything is going to change all at once on that date. So some measures really have already been introduced. Some will be introduced in autumn. Some will be introduced on the 1st of January 2021, and some will not be introduced for a couple of years. So it's a system that's going to be introduced gradually. And what we know about this future system is based on the reports and recommendations by the Migration Advisory Committee, or MAC. So that's the body that advises the government on what immigration policies should be, and on government policy documents and government announcements that have been made. Before we get into what's going to change, I also just want to clarify the term points-based system. So a points-based system, a true points-based immigration system, is one where characteristics of an applicant can be are assigned points, and those points can be traded between characteristics, so that an applicant can make up for a shortfall of points in one characteristic with a lot of points in another characteristic. And generally, the way points-based systems work elsewhere in the world where they're employed is that they're not an overarching immigration system. There will be 1 or 2 points-based routes in an immigration system. Now, you might have heard of the UK's existing points-based system. We have a system that's called the points-based system, but in fact, it's gradually become a points-based system in name only. There's only a tiny area where there's a points assessment made, and otherwise it's actually a system of strict criteria being applied. So for example, you would need, you would need to fulfill 3 characteristics. You're assigned 25 points for each of those 3, and you need 75 points to qualify. So it's not a true points-based system that we have. Okay, so in terms of the agenda for today, we're going to be talking about sponsored skilled workers and Tier 2 general in particular. We're going to be talking about entrepreneurs, and really by entrepreneurs I mean anybody who's self-employed or starting a business. And we're going to talk about low skilled workers, EEA nationals, so that's European Economic Area nationals. And we're also going to be talking about the government's plans for a digital immigration system. Okay. I should say before we start on sponsored skilled workers that we're not going to be talking very much about COVID-19 and its effects on the immigration system this evening. But I am planning a webinar on that. Would you like to give a show of hands to see who would be, so I can tell who would be interested in a webinar on COVID-19? Okay, a few of you. All right. Yep. All right. So that's definitely something something I'll do then. Thank you very much for raising your hands, letting me know. Okay, great. Let's get started for now on sponsored skilled workers. Now, again, as I said, we're going to concentrate on Tier 2 general. The Migration Advisory Committee has recommended that the Home Office not change the Tier 2 intra-company transfer route, which is for employees transferring from overseas branches. And the Home Office has agreed that they're not going to do so. Now, Tier 2 general is the route for new hires from outside the UK to come to the UK, and it might not be called Tier 2 General in future, but it will be, you know, this route will exist in some form. So it's for new hires that are not from a related entity overseas. They're new to the company, and in order to sponsor a worker under this route, an employer first requires a sponsor license, and that's the authority to sponsor workers, non-EEA nationals, to work in the UK. The individual needs that job offer, and they need English language skills. And in terms of the job, the salary has to be at least £30,000 annually, or the specific salary minimum threshold for that job, and those are listed in the immigration rules. So it has to be the higher of 30,000 or the job specific minimum salary. And the skill level is graduate. It's also called NQF 6 sometimes. Now, the process for Tier 2 General usually involves fulfilling the resident labor market test, which usually means advertising the role for 28 days or more, and also requesting a restricted certificate of sponsorship. So there's you might have heard of a cap on sponsored workers, and that's where the restricted certificate of sponsorship comes in. Basically, there are 20,700 places of this type available per year. This type of certificate of sponsorship, which is the work authorization that's assigned by the employer, is to be used for new hires from outside the UK who are earning £159,600 or less annually. And the 20,700 places are allocated on a monthly basis. And this is the only area of the current system which does involve points. So for example, a job that's on the shortage occupation list is awarded a lot of points when determining whether they will get one of these 20,700 slots. Now, what's happened historically is that the cap has only been reached twice, and each time the Home Office kind of wiggled things around so that the cap didn't bite, if you will, for too long, and people were able to assign restricted certificates of sponsorship and sponsor the people that they needed to. So that's the current Tier 2 General system. Now, the Home Office asked the Migration Advisory Committee if they could introduce a points assessment into the salary characteristic for Tier 2 General. And the Migration Advisory Committee, or MAC, said very clearly that Tier 2 General is too, the characteristics that are involved are too few. And so it's not worth packaging it as a points-based system. It should be a strict criteria system. I'm just going to look at this question that's been asked here. We have the question for minimum salary. Is it possible to have different salaries during the first year? For example, starting off on 2 weeks of training on a minimum wage and then the full salary. As long as both of those salaries are always above the threshold, then yes, it's fine to have two different salaries. You should report the change in salary when it happens, and the initial salary will have to meet all the requirements for the role. I hope that's helpful. Okay, so we discussed what the Home Office asked the MAC whether it should do, and the MAC's advice, which was Tier 2 General should not be a points-based system. Don't introduce points into the salary assessments. In fact, it's pointless, they said. So let's do a little poll here. What do you guys think the government did? Did the government Did the government follow the MAC's advice not to introduce points into Tier 2? You should be able to view the poll. I see some of you are already voting. And just wait a second to give others a chance to vote. Does anybody else want to weigh in? Did the government follow the MAC's advice not to introduce points into Tier 2? Okay, great. So we have more votes. We have 17 votes for no, the government, 18 votes, 17 votes for no, the government did not follow the MAC's advice, and 1 vote for yes, the government followed the MAC's advice. In fact, the government did not follow the MAC's advice. I'll share the results so you can see. So basically what the Home Office did was to shoehorn a points assessment into the Tier 2 general visa route. And you'll see this is what the points assessment will look like. So you'll need 70 points to qualify. And you'll see the first 3 characteristics here are not tradable. These are strict criteria: a job offer, the job being at the appropriate skill level, and English language ability. So for those, you would get a total of 50, okay? How can you make up the other 20? Well, you can meet the salary requirement, or you could be in a shortage occupation, or you could have a PhD in a STEM subject that's relevant to your role. Each of those would get you the necessary further 20 points. Otherwise, you could do a combination of having a PhD that's relevant to your job, but not necessarily STEM, and having a salary above £23,040. So you'll see, as the MAC said, there aren't a lot of different characteristics here. It very easily could have been packaged, and probably it would have made more sense to package this not as a points-based system, not as a points analysis, but rather as a strict criteria system. We've got another question here. What level is the English language test? I think it's A1, but I'll have to double check. So just to compare the Tier 2 general current system with the proposed system, the employer is still going to require a sponsor license, and the individual still needs a job offer and will still need to demonstrate English language ability. The job is can be at a lower salary level, so the salary levels will go down. And really, you could say that rather than a points assessment, there are basically exceptions to the minimum salary level for shortage occupation list roles and PhDs. And then the requisite skill level is going to drop to A level to include medium skilled roles. And another way of saying that is National Qualifications Framework 3 or above. Now, what's more significant is that they're going to abolish the resident labor market test, and they're going to abolish the process of requesting restricted certificates of sponsorship, or that cap or limit on certain types of Tier 2 general migrants coming to the UK. That's great because both of those are very faffy parts of the process. And in particular, in combination, they can really add a lot of time to the whole application process. So for example, if you have to have finished your resident labor market test before you request a restricted certificate of sponsorship. Now, if your 28-day period ends on the 6th of a given month, then you'll have to wait until at least the middle of the next month to be able to know whether you're granted a restricted certificate of sponsorship, because you request one by the 5th of any month for a response by the middle of that month. So the timing issues really do complicate the process. So it'll be great if they do abolish both the resident labor market test and the restricted certificate of sponsorship process as planned. Just going to look at another question we have here. Is the job shortage list the same as current, or will it change? The plans are for the shortage occupation list to change much more frequently than it currently does. And at the moment, it does also change from time to time. The last time it changed was October 2019, and a whole raft of jobs that had not been on the shortage occupation list previously joined the list, including lots of tech jobs, engineering jobs, architects, graphic designers. So lots of different sectors now benefit from having a number of roles on the shortage occupation list. But the government envisages that the Migration Advisory Committee will advise on shortages much more often, and that the shortage occupation list will change much more frequently. So what are the problems with the proposals for Tier 2 General? Well, it does seem that there's going to be a disproportionate drain on the resources of small and medium-sized enterprises. So in some of the initial plans for the future of sponsorship, the government had floated the idea of various sectors having organizations that would have an umbrella sponsor license that smaller businesses within those sectors could use, instead of each having their own sponsor license. So those plans seem to have been abandoned, and excuse me, and the government is now encouraging businesses to apply for sponsor licenses themselves to prepare for the future immigration system. That's the government's advice. So the process is quite time-consuming and admin-heavy, particularly because you have to ensure that you'll be fulfilling the sponsor duties that are required. So record-keeping duties, reporting duties, compliance duties, to be able to maintain your license. The other problem is that it's still going to be very complex. I mean, abolishing the resident labor market test and the restricted certificate of sponsorship process is great, but the system is still going to be extremely complex. I'm just going to look at some of the questions we've got in now. Can you currently submit a job in the shortage occupation list, but is set at RQF level 3? Yes. So the graphic design role is an RQF 3 level role, but it's in the shortage occupation list. And so that's an exception to the current skill level requirement of RQF level 6. Next question is, will there be changes to sponsor license criteria? I imagine you mean the criteria for when you're applying for a sponsor license. I haven't heard anything about that. So I don't know is the true answer there. Then we've got, can we get the presentation and recording of this meeting for our reference? Yes, that will be circulated later. Okay, let's move on then, if there are no more questions about Tier 2 General, sponsored skilled workers. What can businesses do to prepare? Well, as I said, even the government is now advising businesses to apply for a sponsor license to prepare for the future immigration system. If you already have a sponsor license, then I would recommend that you conduct a mock audit of your sponsorship systems. So that basically involves, ideally, an immigration solicitor like myself coming in and kind of pretending to be the Home Office, reviewing your personnel files and your systems to ensure that you're satisfying your sponsor duties. It will often be the case that a business will apply for a sponsor license on their own and it will be granted because the Home Office won't necessarily come and visit you or interrogate your systems. They'll rely on your declaration in the sponsor license application process that you have the requisite systems. And then a few years down the line, they will come and pay a visit, and it will turn out that everybody's been working illegally because the business hasn't been doing things quite right. And it can have a devastating effect on a business. So it's definitely worth doing a mock audit, particularly if you applied for your license on your own. Last year in May, the Independent Chief Inspector of Borders and Immigration released a report including a suggestion that immigration enforcement shift its focus from raids on ethnic restaurants, basically, and its focus on civil penalties to actions against sponsors and to their power to close business premises down. Because those would have greater deterrent effects. So it's more important than ever that sponsors are compliant with the sponsor duties, because they will start to feel the effects if not. I see we have another question. How complex and robust do the HR policies and systems need to be? Is there a minimum compliance level? So most of the required HR systems are simply HR best practice, but there are a few that are specific to sponsorship. So, keeping track of visa expiry dates and things like that, you will need particular systems. The list of duties that you have to fulfill are quite long, but once the processes are in place, it should kind of operate on its own. There are definitely, minimum systems you need in place to fulfill your sponsor duties. And another question, would it be possible to get an outline for a mock audit? I'm not sure what you mean, Bronte. I'll get back to you on that if that's all right. Okay. So what else can you do? Sorry. What else can you do? You can budget for an increase, a planned increase in the immigration health surcharge. So in October 2020, October of this year, the standard adult immigration health surcharge is going to increase to £624 per year of visa duration from the current 400. And for children, it's going to be £470 per year of visa duration. So another thing you should do to prepare is to simply budget for that. I see we have another question. What's going to happen to the immigration skills charge? I don't know, Musa. I haven't heard anything about changes to the immigration skills charge. So my guess is that it will stay the same, but I haven't heard anything on that point. Okay, seems we have another question on, is there a reason we should apply for a sponsor license before the system changes, asks Lola. Well, it's just to kind of be prepared for when the system is in place. So the sponsor license application process can take a few months. So it's worth, getting started now. There probably will be a rush for them when the new system is in place. A sponsor license is valid for 4 years, and then you have to apply to renew. So I guess you should consider that, if you don't have plans to use it before the future immigration system is in place, then you might be unnecessarily shortening the time during which you get to use your initial grant of a sponsor license. Downloading these slides. Now, I have to admit, this is my first Zoom webinar, but I'll do whatever I can to make all of the resources available afterwards. Thanks for the question. Okay. Let's see if there's another question. No. All right, let's move on to entrepreneurs. And again, by entrepreneurs, I just mean anybody who's self-employed or wanting to set up in business in the UK. So what does the future immigration system have planned for them? Well, a lot of focus is on modifications to the current global talent visa. So this is a route for skilled workers without a job offer. And the current global talent route works as a two-stage visa process where first the applicant is endorsed by an organization that's relevant for their field. So for example, if they've set up tech businesses before or they're a techie, then they would be endorsed by Tech Nation, which is a UK tech organization in that field. Now, the bar for this, for endorsement under this route is very high. So there were only 600 successful applications last year. And the Migration Advisory Committee considers this visa route a failure for that reason. There's very little take up. So there's a limit on this visa type of 2,000, but obviously, you know, it didn't come anywhere near reaching that limit with only 600 successful applications last year. So the Migration Advisory Committee, the MAC, suggested that this is the route that the government should concentrate on if it wants to implement a points-based system, a points-based assessment for a visa route, not tier 2. I see we've got another question. Will there be drinks after this session? Paolo, you're so naughty. You are welcome to drink, Paolo, after this session. All right. So the Home Office, however, is quite cold on the idea of modifying this route into a points-based route. They've said they're going to take it very slowly. They're going to proceed cautiously. Now, what did the Migration Advisory Committee suggest that this route look like? So the Home Office asked them to look at the systems in other countries that use points-based visas. So they looked at Canada, they looked at Australia, and again, in these places, they found that there's no kind of overarching points-based immigration system. Rather, there are specific visa routes that are that involve points assessments, and others that don't. And they suggested the following as a kind of structure for the future global talent visa. First of all, that it should be a system based on expression of interest. So rather than apply directly at one go, applicants would register their interests. They would complete a profile and they would enter into a pool of candidates that the government would assess on the basis of points attributed to various characteristics on a monthly basis. And there would be a cap on a monthly basis. So the government would only choose a certain number of applicants from the pool to invite them to make a full application on the basis of their points profile. Canada has a very similar system. So what would some of the characteristics be on which points would be granted? Qualifications, age, relevant work experience. The Migration Advisory Committee suggested extra points for having studied in the UK, and also points for skills that would contribute to priority areas. So for example, STEM or creative. I'll just check if that's a new question. Okay. So the Migration Advisory Committee suggested that English language should be a strict requirement. And again, the government is not very keen on implementing this route very soon. So it's very unlikely that this would be one of the routes that's in place by 1st of January, 2021. It's likely not to appear until much later than that, even though this would be the true points-based route in the future system. Okay, does anybody have questions on that? On the proposed global talent visa? Okay, let's talk about some other visa options that are open to entrepreneurs and self-employed people. So there are the innovator and startup routes, and these two are two-staged routes involving endorsement, first of all, and then the use of the endorsement to support a visa application. So in the innovator and startup routes, the endorsing bodies for innovator are for the innovator visa applicants are accelerators, venture capitalists, and those types of entities. For startups, it's going to be universities, and the various endorsing bodies will have their own criteria for endorsement, and often innovators will require innovator endorsing bodies will require that you follow their program, for example, their accelerator program, their entrepreneurship program, before they endorse you. For startups, some universities will only endorse their own graduates. That's mostly the case. There are proposals for automatic endorsement on a points basis and fast track entry for the future innovator and startup routes. At the moment, the uptake on innovator in particular, but and also on startup to some extent, is pretty low. So, you know, if the Migration Advisory Committee thinks that the global talent route is a failure because only 600 applications were successful, then the innovator route is a total washout. Let's do a little poll, if you don't mind, about the innovator visa numbers. Okay, so about 1,000 entrepreneur visas were made in the 6 months from March to September 2018. The innovator visa replaced the entrepreneur visa in March of 2019. So how many innovator visas were made in the same time period in 2019? Were there about 1,000, about 2,000, 574, or 14? Just give some of you a chance to vote. Decisions. Okay, I've got a couple of votes for 1,000. Got 4 votes so far for 574. That's a convincingly specific number, isn't it? Also got 3 votes for 14. Very low number indeed. Okay, any other votes? All right, betting is closed, ladies and gentlemen. The correct answer is 14. There were 14 applications made. Ultimately, 12 of those were successful. Now, the numbers have gone up since then, but not hugely. So absolutely, the innovator route is, in its current form, a total washout. It's just pretty much useless. The startup route has been used more, and so probably would need less modification, but the innovator route has got to change. And what's most likely to happen is that more endorsing bodies will be included, and that will allow for more applicants. And hopefully they'll extend beyond tech, because at the moment you would only be able to get endorsement for a tech business. So another visa option is the tried and tested representative of overseas business visa route. I love this route. It's very well established. It's very reliable. You know, it involves a lot of documentation, but you know, we know exactly what documentation it is that's required. So I wouldn't dismiss this out of hand. You might also hear it called the sole rep visa, the sole representative visa, and that's because it's for businesses that are already established overseas to establish a UK branch, and they would do that by sending one employee over. So don't forget the representative of overseas business visa. It's quite useful. All right, if there are no questions on that, I'm going to move along and let's talk about low-skilled workers now. So in December of 2018, the government stated that it was going to, that it was considering a 12-month temporary visa for workers of all skill levels. So they could be low-skilled workers and they wouldn't need a job offer. They could come to the UK for 12 months and then they would have to spend 12 months outside the UK before returning. It seems that the government has completely abandoned plans for that 12-month work visa, which was to be for all skill levels. Instead, in the future immigration system, the need for low-skilled work is proposed to be covered by specific schemes to address particular shortages. And these would be capped. Only certain numbers would be able to come to the UK under these schemes. The visas would be temporary, and it would be the MAC advising the government on the shortages, which we discussed a bit earlier. Now, some of you are probably familiar with this, with some of these schemes already. Raise your hands if you've heard of the seasonal workers pilot. There's a pilot scheme for seasonal workers. Yeah. Yeah, I thought some of you would have heard of it. So basically that's the, that's an example of the scheme that the government has in mind for to address shortages of low-skilled workers. Now, the problem with these schemes is that they're not sufficiently responsive. So with the seasonal worker scheme, for example, it was introduced as a pilot initially last year with 2,500 workers being allowed in, and now it's expanding to 10,000. But this is based on a shortage reported, 4 years ago of 70,000 workers. So I just don't see that that type of scheme is going to work to fill the job shortages for low-skilled workers. There are a few other schemes, a few other visa routes for low-skilled workers. So there's the Youth Mobility Scheme. This is a 2-year visa for relatively young people, 18 to 30-year-olds. And this is likely to expand to what the Home Office deems low-risk countries. So you will have heard a lot about the egalitarian nature of ending free movement, because we're no longer going to differentiate between EU nationals and people from other countries. But in fact, there's a lot of mention of benefits going to nationals of low-risk countries in the future immigration system. And we can guess at which countries those would be from those that are allowed to use the e-gates. So that would include Canada, the US, Australia, New Zealand, Japan, South Korea, and the EU states are likely to also be considered low risk in the future immigration system. Other schemes for low-skilled workers that are planned, or which could include low-skilled workers, are the post-study work route for students. So the government has said that from 2021, I think I've heard January 2021, any UK students who are overseas nationals and graduating after that date will be able to stay in the UK and work or look for work for 2 years. Interestingly, one of the possible effects of the COVID-19 pandemic on the future immigration system is that politicians have recognized that many low-skilled workers are crucial key workers. So a Tory MP raised this issue in Parliament the other day. I think his name is Steve Double. And Priti Patel agreed to keep this point under review. So COVID-19 could change the government's plans for the future immigration system. Okay, let's talk about EEA nationals. So that's European Economic Area nationals. So we are in the post-Brexit transition period now, and you'll often hear people talk about whether there will be a deal or not. From an immigration perspective, Brexit happened with a deal because it happened with the withdrawal agreement in place, agreed by both parties. Now, we're going to be in the transition period until at least 31st of December 2020, although it might be extended for up to 2 years. Now, because Brexit has come to pass, it is absolutely mandatory that any EEA nationals and their family members who are in the UK before the transition period ends, so as far as we know for now, before 31st of December 2020, and who want to stay in the UK beyond the deadline for registering for the EU settlement scheme of 30th of June 2021, it's mandatory that they register for the EU settlement scheme. It doesn't matter if they already have documentation under the European Economic Area regulations. So it doesn't matter if they have a residence card or documentation of permanent residence. They still have to register for the scheme. I see there's a question. I'll go see what that is. Will the 31st of December deadline be postponed due to the COVID-19 pandemic? It very well maybe, I don't know. They'd have to agree a new financial provisions by the end of July, I think, for that to happen. So I'm not sure whether the deadline will be extended, but it's a possibility. Now, I just want to stress that it's mandatory to apply for the EU settlement scheme, because I still meet people from all walks of life, you know, from professors to au pairs to retail workers, and nobody seems to appreciate that it's absolutely mandatory that you apply for the EU settlement scheme. So you can apply for pre-settled status if you've been in the UK for less than 5 years, or settled status if you've been here for 5 years. And if you have settled status, the government's saying it will only be lost if you stay outside the UK for 5 years. And one thing that people don't realize is that you can apply for this scheme from outside the UK, which is particularly pertinent now because some people who have accumulated the requisite 5 years of continuous residence in the UK to be eligible for settled status are now stuck outside the UK due to the pandemic. They can still apply from outside the UK, and I can help with that if anybody needs help with that. Let's check the questions again. In case where already obtained settled status and following this is a British passport as an EU national, then there is no difference if they leave for 5 years. I'm so sorry, Katrina, I don't understand that question. I will get back to you on that later. Okay. Now, what happens? So this is all, we've talked about what EU nationals and their family members who were here before the end of the transition period can do. And I should say as well that there are some family members who can join those EEA nationals who are here before the end of transition later. But let's keep things simple. What about EEA nationals who come after the end of the transition period? Well, they're simply going to have to apply under one of the visa routes in the future immigration system. Now, let me ask you something. Let's say there's somebody who, an EEA national, who's here before the end of the transition period. So they're here before 31st of December 2020, but they don't apply for the EU settlement scheme. The deadline isn't until 30th of June, so they haven't applied yet. The end of the transition period comes to pass. And so what documentation would they have? If anybody has an idea, you can just put it in the question and answer. I will get back to you, Alex, on your question. All right, so you can, somebody who is here before the end of the transition period but hasn't applied yet is going to have an EEA passport. They're not going to have any other status, documentation or digital status to prove their rights. That's the same as what somebody's going to have who comes after the 31st of December 2020 and is coming as a tourist, an EU national coming as a tourist. So although the deadline is 30th of June 2021, it's really actually very important to apply before the end of the transition period, which is 31st of December 2020. So if you know any EU nationals who haven't applied yet, or if you're in a business where some of your EU national employees haven't applied yet, please do encourage them to apply. Okay. So what can employers do? Well, definitely ensure that your employees have registered for the EU settlement scheme. And registration can be done from overseas. I do think it is just the settled status that can be applied for from overseas, Alex, but I'll check that point. And again, apply for a sponsor license, because if you've been employing EEA nationals, you think you're going to hire more EEA nationals in future, you're going to need a sponsor license. You're likely to need a sponsor license to be able to do that. Okay, let's talk about the future digital immigration system. So this isn't necessarily going to happen for a while. The government has said it will be in place from 2022 or beyond 2022. But we can guess pretty well what it will look like, because the EU settlement scheme is already offers digital status and is a digital process in a lot of ways. So basically, the government envisages that migrants will be sharing their digital status with employers, landlords, the NHS, and banks to demonstrate their rights. Migrants would generate a share code. Under the current system for doing this, the share code is valid for 30 days. And it's called a share code because the migrant then shares it with the employer or the landlord, et cetera, who's supposed to be checking their status. And the employer would get an online confirmation of the migrant's right to work, and they could save that to PDF, for example. In addition to digital immigration status, there's a plan for electronic travel authorizations. So this is similar to the US's system for travel authorizations, which is called ESTA. So you want to raise your hand if you've participated in ESTA, if you've had a ESTA before. Yeah, loads of people have. That's what I thought. Yeah, so you're quite familiar with it. It would be very similar, and this is likely to be put in place for European nationals. And the important thing to remember about these travel authorizations is that they are not visas, actually. These are visa waiver programs. So it's a different status, actually, to a visa. It's a visa waiver program. It's likely to operate in a very similar way to the US ESTA program. So you would apply online before traveling, and it's, as you know, quicker, easier, and cheaper than a visa application. There's also going to be electronic visas, or e-visas. And the government has said applicants could use an ID verification app. So this would kind of be instead of going to a visa application center. And given the current circumstances where a lot of visa application centers are closed, all of the visa application centers in the UK are closed, it might be, it's even more important that they do bring this in future. And again, we can look to the EU settlement scheme to see what it might be like. So basically, there's an app that's used in the EU settlement scheme to verify people's identity, where, first of all, the personal details page of someone's passport is scanned. And then the app, it's really nifty. You put your phone on top of the passport, and the app reads the chip in your biometric passport. And then you can also take your photo through the app, and the app will scan your face digitally. So that's likely what's going to be involved with these future electronic visas. And then carriers, so like airlines, can just conduct automated checks on these e-visas. Just see if we have any more questions. No. Another element of the future, oh, yes, we do, sorry. Let me go back and look at the questions. Oh, you're most welcome, George, for this presentation. Okay, you can ask your 2 questions. I'm just going to go ahead while you type them in. So another aspect of the data sharing, another aspect of the digital immigration system is data sharing. So And again, the EU settlement scheme is already using data sharing, but basically the government thinks that it will be able to draw on, the Home Office will be able to draw on data from HMRC and the Department for Work and Pensions to verify migrants' compliance with the terms of their visas. Now, this could change things a lot for sponsors' reporting duties and record-keeping duties, because basically at the moment, a sponsor has to keep various documentation to be able to demonstrate that they're paying a migrant at the requisite salary level. But if the government's able to check the migrant salary through Department for Work and Pensions or HMRC, then it could possibly reduce the sponsor duties, the burden of sponsor duties on sponsors. Okay, let me go back and check the questions. Checking the work permit. Can I ask for? So George asks, I didn't really get the advantage of digital immigration in terms of checking the work permit. The employer can simply ask for the work visa to check the applicant's status, correct? Yes, but it's easier just not to have a piece of paper, if you will. I think that's the point. But, you know, I'm not making the policies. See, okay. Thanks for your question, George. Okay, so, you know, just as we look to the EU settlement scheme to see how these various elements might work, we can look to see what the problems might be. So some problems that have arisen with data sharing in the EU settlement scheme are that the data that's available is inaccurate, or sometimes the data is not available. So I've helped with applications to the settlement scheme of various members of one family who all moved to the UK together. Some are recognized as having settled status, and then others within the same family are not. They're only recognized as having pre-settled status. So there are definitely issues there. And then there's also a danger of a deference to automated decision making. So again, in the EU settlement scheme, the government will go run the checks on the data it has, and it will propose to the applicant who say might be applying for settled status, we don't think you have settled status based on our records. Would you like to apply for pre-settled status instead? And now an applicant not knowing, you know, the difference between the grant of rights with each of those statuses, which are very different, might just go for the pre-settled status. So there are some dangers there, which hopefully will be addressed as the policies roll out. Okay, just checking if there were more questions. No, it seems that's it. So that's it for the materials I have prepared for you. If you have any questions, please do stick around and ask me over the question and answers, or you can always email me. See, my email is there. It's samar@spencer-west.com. Feel free to get in touch with your questions. Let's see, we do have a few more questions in. So somebody asks, currently there's a fairly easy transfer from Tier 4 graduates to the Tier 2 visa. With the new student post-study work route, is there any change to requirements, processes, etc.? So these are kind of two separate aspects of the immigration system. So there are benefits for Tier 2 applicants who are switching from Tier 4. I don't think that any of those benefits will be removed, but they will be kind of equalized because of the removal of the resident labor market test and the removal of the restricted certificate of sponsorship process, because those are some of the main benefits of switching from Tier 4 to Tier 2. So indirectly, it will be affected. In terms of the post-study work route, that's a separate route. It's a 2-year visa, and people holding that visa would then be able to switch to a work route. There's also a proposal for Tier 4 students who finish their course, their UK degree, and leave the UK to still benefit for a period of 2 years from the switching provisions. but it's only a proposal at this stage. We'll see if it comes into effect. Another question is, when does the new system come into force such that we won't need to go through the labor market test anymore? It hasn't been specified, unfortunately. We don't have a date for that. Thank you, Musa, for attending. And yes, please do stay safe, everyone. Another question, would you say the current immigration system is stricter or lighter in comparison with the proposed system? I think the current system is stricter, mostly because of the changes to Tier 2, and in particular, the change to reduce the requisite skill level and to reduce the requisite salary level. So many more businesses are going to engage with Tier 2 than previously because of the opening up of those roles to eligibility for Tier 2. So in that sense, it's definitely lighter. But at the same time, free movement is ending, and that's a very light touch system in comparison to other elements of the immigration system. Lola asks when all these changes will come into effect. So they'll come into effect gradually over the next few years. In a sense, the government has already started to move towards the future immigration system. So for example, in the latest immigration rules changes, they've paused the salary threshold requirements for settlement. So by 2024, people were going to have to be earning above £40,000 to be eligible for settlement. At the moment, it's 35,000 something, and they've kind of frozen it there. That's likely in response to the Migration Advisory Committee's recommendation that settlement be reviewed entirely and possibly revised in the future immigration system. Some provisions will take effect in autumn. Some provisions won't take effect until next year. Oh, Shafina, you're so supportive. Thank you. I'm very glad you found it interesting and informative. No worries, Jane. So Jane asks, is there to be an additional PBS to run alongside Tier 2 where migrants at RQF 3 and above are pre-authorized and employers don't have to sponsor? So I don't think anything would necessarily run alongside Tier 2. So Tier 2 is going to open up to RQF3. So the skill level for Tier 2 is dropping down to medium skill level or A level, which is RQF3 and above. And there were initially discussions about pre-authorizing migrants and employers not having to sponsor, these kind of umbrella systems of sponsorship. But the current government hasn't mentioned that at all. So I don't think that those plans are going forward. I'll let you know if I do hear anything further on that. Great, I'm glad that's clear. So if there are no more questions, that wraps it up. Please do keep in touch. Most of all, stay safe. Thank you so much for joining this evening. It's really great to see you all. All right, I'm going to end the meeting now. There are some notes in the chat. I'll have to get back to you on those. Thank you very much, everybody, and take care. Good night.